And the clerk, please. The Honorable Supreme Court of the State of New Mexico.
Please be seated. Well, good morning, everyone. Good to see you here. Court will call the case of Kaushal versus Santa Fe Community Housing Trust. I hope I pronounced that right. It's now our case number 40119. And before we begin, I'd like to introduce to my far left, Judge Curtis Gurley from the 11th Judicial District, former Chief Judge. He has graciously agreed to sit with him on this case. And to my far right, Judge James Hudson, the 5th District, also former Chief Judge from the 5th. And he has also agreed to sit on the case. So we thank them for coming from their parts far and wide to come here and sit today. So with that, would counsel please enter your appearance and you may proceed.
Good morning, Your Honor. This is Dave Ferris on behalf of Dr. Kaushal.
Thank you. Okay, you may proceed.
May it please the court. Not far from here, there's a property that has sat vacant for years during the course of this litigation. Mr. Kaushal is here today to ask the court to fix a number of errors in the Kaushal 2 Court of Appeals opinion so that he can put that property back into use. There are 3 errors that Mr. Kaushal would like the court to address. First, the Court of Appeals held that the reduction created a tendency in common with the non-redeeming errors. I believe that was error. Second, the court appears to have revived. Sorry, I got a weird. You're getting an echo?
No.
Okay. The court appears to have revived the trust's junior second position lien. That's error. And third, although I don't think that this court needs to go that far, and indeed the Court of Appeals recognized the discussion was premature, there were a number of statements it made relevant to the doctrine of equitable contribution that we believe were also error. I understand also the court has some questions that it will get to about jurisdiction, and I'll take those as they come.
I actually think you should start there.
Okay.
Why would we discuss any of this if we don't have jurisdiction?
Indeed. And certainly I'm at a disadvantage here in that I have not seen any briefing. The court has not seen any briefing. And so I'm going to go where I think the court is concerned, and you will.
If I could, maybe I could direct you. So the question is, was there proper service on the unknown heirs, devisees, and legatees of Lenora Pacheco?
Okay. And I'm gonna frame that just a little bit higher. And what I heard from that question is that the court's concerned about whether there is personal jurisdiction, not whether there's subject matter jurisdiction in this case. Okay. This court, sorry, I don't have these cases as well in hand. In Kepler v. Slate, 1995, NMSD 035, this court explained that there are two manners in which one can get foreclosure, in personam and in rem, and that's going to affect what kind of service is necessary. And a lien holder can pursue both of them, either of them or both of them. They can pursue them both at the same time, but the requirements for jurisdiction are different. So where I'm going to start in answering your question, different from where I'll end up, which is I think where you want me to be, is that the court had jurisdiction for an in rem foreclosure, and that here the actual judgment of foreclosure, which is at RP 280, was a stipulated judgment of in rem foreclosure. Now the court, I think unquestionably, had in rem jurisdiction here. And why is that? This case was filed in 2014. And at that time, the only owner of the property was Lenora Pacheco. They originally thought maybe her ex-husband was an owner, but later turned out he had divorced her long before she purchased the property. So just Lenora. The plaintiffs could not find Ms. Pacheco. There's a motion for service by publication at RP 72, where they said that they believed she had moved to Las Vegas, but their investigator couldn't find her. And so they asked the court to serve her by publication. And I'm sure as the court's interested in this, it has already looked at the affidavit of service by publication, which is at RP 84, and carefully compared that to Rule 1-004K 2, 3, and 4. And I'm going to walk through those just a little bit. I'm going to start with K3, which are the requirements as I understand the rule. So take that for what it's worth. K3 is the requirements for in rem service by publication on property. And there's 3 requirements, only 2 of which I believe apply here. The first is that the service must contain the street address of the property, and you'll see that it does. The third is that it must contain the legal description. You'll see that it does. The second is that if there's a Spanish land grant involved, that it identify that. And as far as I know, that's not an issue. So I think, based on what I've seen and the law that I've looked at, that service by publication in rem was correctly achieved by the notice that got published. So step 1 of my answer, and I'm getting to in personam jurisdiction, I promise you. Step 1 of my answer is that that publication was sufficient for the court to obtain jurisdiction over the property. Of course, Lenora was also served by publication, and I think, again, I had a few days to familiarize myself with this law, but I do believe that that gave the court jurisdiction over the property as well, and over Ms. Pacheco. Now, the problem that I perceive the court to have raised in the Friday filing is that Ms. Pacheco died during the pendency of this proceeding. And our cases, and I want to say it's Jones. There's not a ton of Rule 25 case law, but probably the main case is Jones v. Montgomery Ward. It's a 1985 Court of Appeals case, it's 94. That case explains that on the death of a party, the court does not automatically obtain jurisdiction over the estate. It's closely related to Rule, oh no, I'm talking about Rule 25. Rule 25C, I think would be the relevant part here. Rule 25 is divided into 2 paragraphs, A and C. A is about jurisdiction over people. C is about jurisdiction over successors and interest. I think Jones is consistent with this, that here we're interested in jurisdiction over the estates, so C would apply. And Jones says that you don't automatically get jurisdiction, you have to serve the PR. That didn't happen here. What we do have is service on one of the heirs, and we have the service by publication earlier. Now the court asked me to be ready to discuss statute 39.5. No, that's the. There's a publication statute
Yeah,
that is
515.
515. It's right before the redemption statute, as well as Rule 004 and Rule 25. Rules 25 and 39.515 are procedural rules aimed at providing a mechanism to obtain in personam jurisdiction when a party dies. And I think with one caveat, we didn't have that here, right? There was the trust filed a substitution, but the 90 days didn't start running because the successor never got served with it. I think that flows out of Jones. So that mechanism didn't happen. 39.515 has a number of allegation prerequisites, none of which were met. The original complaint, although it named the unknown heirs, devisees, and legatees, it didn't allege that she was dead. She wasn't, in fact, dead. And so the prerequisites of the statute were met. In the amended complaint, there's another requirement that you have to allege. You have to allege that there's been no administration, and that wasn't met. So neither of those procedural mechanisms really were deliberately used by the plaintiff. And I know the court's aware of this. I will mention that we're in a strange position here.
I think we all acknowledge. I think we all acknowledge that both parties are in an odd position here because this wasn't your action. This is the bank's action.
So there is a case that discusses what should have happened here, right? And what still could happen, right? And that is ACPA versus Martinez. If you give me a second, I will have a site for you. 1978 NMSC 003. Actually surprisingly similar set of facts. A foreclosure case where the debtor was served with default and he later died. The cross claim was filed and served on him, and this whole jurisdiction issue came up for the same reasons. And the parties there did what I believe is the correct thing then and here. They used Rule 1-060B4 to raise the issue. And that brings us back to the constitutional issue, right? The jurisdiction of this court. I know the court has indicated, and I think it's absolutely correct, that there's a question of subject matter jurisdiction. And when I saw the notice, my first thought was that this court, an appellate court, generally does not raise sua sponte the issue of personal jurisdiction. The New Mexico cases on this are a little bit less clear, but in other jurisdictions, those are rooted in Rule 12H, 1 and 3. And in the rules of appellate procedure, I think it's 12.321, preservation rules. Normally, I wouldn't have expected this issue to come up at this stage in the proceeding, absent a party, in this case, I guess the estate or maybe the heirs, bringing it via Rule 60B4 motion. And I still believe that's probably the correct mechanism here.
Don't you think it's fatal, though, just generally speaking, if it's one of the early steps that improper action was taken, that then there is no personal jurisdiction over several of the heirs?
No, Your Honor, for three reasons with that question. First, I do believe that in rem jurisdiction was properly obtained, and we do have an in rem judgment, not an in personam judgment. And so I think it can be affirmed, the foreclosure can be affirmed on that basis. Second, and this I think would require a full briefing or an evidentiary hearing. I'm sorry, I lost my train of thought. Oh, second, one of the heirs unquestionably was served. That was Raymond Pacheco. And you can find that.
Wasn't he served as an unknown heir?
He was personally served. Yes, and you can see that both in the certificate of the state of the record at RP 277 and at RP 158, I believe.
But you'll concede that service on one is not service on all.
I won't concede it because I didn't have an opportunity to research it, and I honestly don't know.
I think you should agree with me. I assume with me that that is the case.
So,
It doesn't save your clients
so there's
or
a
the
number of
parties'
reasons
positions here.
I'm not certain that my client needs to be saved here. I'm working my way through them, but in answer to your question there, ordinarily, other jurisdictions, we don't have case law, I don't think that firmly answers it, will not look at personal jurisdiction sua sponte during an appeal, with one exception, when there has been a default and that party, there's questions of service about the defaulted party. And there they say that the responsibility is on the district court to verify that it had personal jurisdiction sua sponte. I couldn't find.
But what precludes us from remanding all of this to the district court to unravel this?
So what I would say is then Judge Thompson did have this before him. If you look at record proper 277, the certificate of the state of the record, it walks through the service that was there on the heirs.
But it's incorrect. I mean, so that's the problem, is the certificate of the state of the record here is false. It suggests that the service happened when that service was never ordered. And you have to have a court order to go down that path. And so I don't think the district court has actually considered this issue. So what precludes us from saying, nope, go all the way back, and the district court needs to address this perceived problem in the first instance?
Well, I do believe that we have presumptions in favor of upholding a judgment, and that Judge Thomas did actually look at that and conclude that he had jurisdiction. But obviously,
It's based on a false statement.
sure.
So you can't hold then Judge Thompson to having had an understanding of the state of the record when the certificate of the state of the record was in error.
I certainly understand that point of view, and I suppose the court could send it back. Another reason the court might want to consider not sending that back, and I don't know the answer to this, but I'm sure the court's familiar with the way finality works in probate proceedings where like redemption proceedings, there are additional petitions. In Nawala is the case we look at there for the idea that finality is at the end of each one of these separate probate proceedings. Here we're talking about a foreclosure proceeding that was final in 2017 that no one appealed. The court retained jurisdiction, as it does, to take care of ancillary matters, including the sale of the property. The fact was, no one appealed it. It's a final judgment. And perhaps redemption works like probate and is a separate.
Well, no, probate is a statute of repose. It's a very different animal than foreclosure. So the statute of repose doesn't apply in a foreclosure proceeding. I mean, I can't handle thousands and thousands of foreclosure cases as a judge.
Sure.
Very, very different rules. Statutes of repose are a draconian stop to any further action under a judgment. This is more akin to just a general discussion about finality. And there are ways to undo that if there's an error.
Well, I guess what I'd leave you with on the jurisdiction issue, and I don't know if the court even needs to hear about the other issues, certainly would like to address them if it does, is that there was interim jurisdiction here for K3. The requirements were satisfied by that publication. And the ultimate judgment here was a stipulated interim judgment of foreclosure. It wasn't in personam.
Interesting.
So to undo a foreclosure, however many years it's been after, obviously is going to create a bit of chaos here. I guess the bank is not here today. Will refund its money into the registry. We'll have a defective foreclosure similar to it's Western Fluid. I think the cases, all the cases where one of the parties isn't actually made a dependent, although here it would be the senior lien holder. I think maybe the trust redeems, but is immediately foreclosed on by the bank again. And then Mr. Kaushal, who has all of the assignments from all of the living heirs, redeems again if it still remains economically viable to do so. I just asked the
I
court.
puzzled over the same thing, so.
Yeah, so that's not an awesome result, but
Use that technical term.
yeah, I understand, why getting the jurisdictional question right is more important than whether this particular.
An
case-
awesomeness.
Yes. So I'm going to briefly go through the merits of the redemption side of the case, unless the court is not, wishes to consider talking about jurisdiction.
I would just note that our rule 12-321B allows this court to raise jurisdiction sua sponte if it's a issue of general public interest or fundamental rights of a party. I think you'd concede that both of those are present at this point.
That's a decision for the court. Usually the case law will not allow the exception to preservation to be invoked unless a parties ask for it. Obviously, there's no party asking for it here, so I'm not sure that I would concede that that should be applied here.
Thank you.
Walking, and just,
So, but you're saying that somebody that was not served is not complaining, and therefore we should just leave it alone, even though they were entitled to service.
I think that's not really what I'm trying to say here. Two parts. I'm trying to lean heavily on in rem because obviously there are problems in impersonum. But
You've got in rem jurisdiction, but that can't be a basis for cutting off service, getting personal jurisdiction over people that are required to be in the case or named as parties.
they're only required to be in the case for an in personam judgment. The in rem foreclosure is just.
And why are they named as parties?
That would be an excellent question for the bank. I don't have an answer.
Well, I understand where you're coming from.
Okay.
You can talk about the merits if you wish.
Honestly, as I reacquainted myself with this case, the merits side of this is really quite simple. Much more so, I think, than what we've been talking about. The foreclosure itself is pretty simple. This court has 100 years of unchanging case law going back to Community Dot in 1924 that says that the rights of the parties merge into the purchaser. Here was the purchaser. It obtained clear title, not subject to any liens, subject only to the right of redemption. Wheatcroft, First National Bank of Taos versus Wheatcroft in 1931, this court said that the redeemer obtains the same title that the purchaser had. And actually, I think probably the nicest synthesis I've seen of this is Mers v. Montoya, 2008 Court of Appeals case, paragraph 16 and 17, walk through that process of how the purchaser gets clean title and the redeemer takes that. And what a second position lien holder has at that right is the right to any excess funds and the right to redeem. Here, footnote 1 in Kaushal 2 seemed to say that despite the trust having been a party and having foreclosed its lien and having been foreclosed on, it could still exercise that lien on the property after the redemption. And I think as a matter of black letter law, that's just wrong. As for the redemption tendency in common, there's really 3 reasons why that is not correct. The first reason is that this court has said that the redeemer obtains the same title the purchaser had, and that was First National Bank of Taos v. Wheatcroft in 1931. The second is that the statute does not say that a tenancy in common is created with non-redeemed heirs. It says the opposite of that. It says you have the redemption period to redeem where you get nothing. This court in Cortez v. Cortez explained that redemption is a narrow right and that the statute should be interpreted strictly. And that doesn't mean that we should add a tenancy requirement that doesn't exist. And then third, and where I think really the Court of Appeals went astray here, is a reliance on bankers' trust vehicles. And I think it's really important to distinguish the key fact in that case, that there was a co-tenancy before the foreclosure in bankers' trust v. Woodall. Husband and wife owned the property as tenants in common. They got foreclosed on. Each sold their redemption rights to someone else. both of those parties tried to redeem. And the court said that the redemption by one co-tenant inured to the benefit of the other. There are no co-tenants in this case. Lenora owned the property by herself. She bought it after she was married as a single person. And so Woodall really doesn't inform what should happen here.
Can I ask a slightly basic question before you go on? Has the district court made any findings as of yet as to who owned the property at the time of the foreclosure?
If those findings are there, they're in the stipulated judgment.
We didn't find any.
Yes.
So I don't mean to hide the ball on you, but it seems to me that, and this goes to your arguments about potential overreach in Kaushal 2 by the Court of Appeals. It's like they're reaching issues that haven't even yet been raised in front of the trial court.
Yes. I think a very legitimate problem with the way this case has gone in its periodic brief appearances at the district court is that the court has never had a chance to ask, were the heirs here? Who owned the property? These are all things that should be established facts by the time you're up for your second appeal, to your second level of appellate court, and they're not. There's nothing I can do to fix that part of the record here today.
No, agreed. But it's kind of a really basic element here to some of the issues that the Court of Appeals discusses, is as though those things have already been determined.
Yeah, I agree. And I see I'm out of time, so.
You'll have more.
Thank you, Your Honor. Thank you.
Mr. Van Amber.
May it please the court, Ron Van Amberg for the Housing Trust. I'll confirm the the timelines and how these issues were raised in the district court that's presented by Mr. Parents. So I'd like to jump to the issue of what is the effect of the questionable jurisdiction over these individuals. And it's clear that there was a death by Lenora Pacheco. She died. The notice of publication in these proceedings was filed before her death. So the reference to unknown heirs could not apply to her because she had no heirs at that time. Rule 25 also requires that a motion for substitution of parties be filed within 90 days of the suggestion of death. That didn't happen. And even though there was a certificate of the state of the record, which reflected proper service, that was an error. It was referring to the original notice of publication that could not have applied to the heirs of Lenora Pacheco because she didn't have any at the time of the publication. So after the amendment of the pleadings to add Lenora's heirs, there was no further publication. The question then arises as what was the effect of Lenora's death, no service on the heirs, no notice of publication. And what effect did that have on the foreclosure proceedings? Now, as Mr. Farrant stated, foreclosure proceedings can have two aspects. One is in rem jurisdiction. which is jurisdiction over the property. And the other is in personam, which in recent years have not been included in these foreclosure actions, which is jurisdiction over the debtor-creditor relationship between the lending institution and the defendant. Rule 25 provides that unless the motion for substitution is made not later than 90 days after the death is suggested upon the record by service of a statement of the fact of the death as provided herein for service of the motion, the action shall be dismissed as to the deceased party. The language here is questionable because the deceased party is no longer a party because the deceased party doesn't exist. So one interpretation of this is be dismissed as to the deceased party and that party's successors, because that's all that exists would be successors. And that would be the estate and it would be the heirs. There is a significant difference between the nature of joining a party in an in rem action and in an in personam action. In an in rem action, the issue is not whether or not there is any liability on behalf of the defendants. The issue is we're providing due process notice to these defendants so that if they have a claim against the property over which this court has jurisdiction, they're free to raise it. In this particular case, I don't think there's any question, but there was proper notice or joinder of Lenora in these proceedings. She was free at that time to make a claim against the property, which she didn't do. When she dies, then there was an opportunity for substitution of the parties, and that was not necessarily incumbent on the bank to do. That provided an opportunity for the heirs or the estate to come into court and pick up the claim, whatever it may have been, of Lenora Pacheco, and it didn't do that. I didn't find any case law on that particular scenario, but I think what we have here is a court which had in rem jurisdiction over the property. I think originally there was also an in personam claim, but that has not been pursued. And so I think the failure to join the heirs and the failure to, let's say, get a personal representative appointed to a creditor, that does not affect the jurisdiction of the court in its in rem capacity. Instead, it was incumbent upon Lenora's heirs to pick up the mantle and come into court and show that they had some interest in the property.
But
So
isn't
go ahead.
I'm sorry.
No, go ahead.
Isn't that the problem? I mean, the bank knew of two heirs, Ray Pacheco and Brian Pacheco. They knew that the day they filed the amended complaint and had the false allegation in their complaint, that they'd made diligent efforts to find heirs and they could find none. But they were aware of two at the moment that was filed. Do you agree with that?
I'm not sure if they knew who they were, but
It's in the record. So if they're doing their job, they should know that. So what about our probate statute that was talked about by petitioner? Those heirs, didn't the property pass to at least those two? Didn't they have an interest on that day that the complaint was filed, the amended complaint?
Yes, but
So how could they come and raise the issue if they're not told about it, if they're not served with process?
well, they are the heirs of Lenora Pacheco. They are the successors in interest.
Yes.
And they had an equal due diligence to protect their interests. They,
Oh, but the bank has an obligation. I mean, I'm hard pressed to write an opinion that says the bank didn't have to do anything here. And I go, you guys don't represent the bank. Nobody here does. But in the foreclosure context, let's be clear, I don't cut banks any slack. And here we would be writing something that would say, well, they probably should have known about these heirs, but they didn't have to do anything. All of the onus is on the heirs. That's just antithetical to the state of New Mexico's approach to foreclosure cases.
I understand the court's position.
Yeah, I mean, I can't, so to go to Judge Gurley's point, saying, well, the bank knew or should have known, certainly, about these heirs because their names were in the record, but they have no obligation to do anything. I don't know what to do with that.
No, I understand the position of the court. I'm, the only answer I have is relating to the in rem jurisdiction that the court had and the difference in the function of providing notice or service by publication on heirs. And when there is a dismissal of the complaint against the deceased party, I can only interpret that as being a dismissal of the complaint as against the deceased party and her successors. And if there's a dismissal of the complaint against the successors in interest, then that means they do not have an interest in the in rem property.
Including the right to redeem.
They probably have a redemption right.
But how do they exercise it if they're not given notice?
They sold it.
That was well after the fact.
After the default stipulated judgment.
Right, but that's the redemption happens after that.
I understand.
But if service in an in rem proceeding, as you said, service in an in rem proceeding is to allow claimants to make possible claims against the property, that's the due process, that's the process that is due to potential claimants.
Correct.
Heirs and unknown heirs are potential claimants. And that step was missed here. Doesn't that account for something, even though it's an in rem proceeding?
Well, the question is, upon the death of the original plaintiff, whose burden is it to intervene to pick up the claim? The bank's position is we gave notice and we joined Lenora Pacheco. And
then the bank conveniently doesn't substitute the party? I mean,
well, unless the obligation for substitution rests with
somebody who doesn't know about the litigation?
they know the mother, they know that they're successors. They should know that she died. They should know that there's a foreclosure action. I mean, I think the rare instance when families are so alienated, they have no idea what's going on with a foreclosure action against their mother, which has been going on since what, 2014.
Let me ask you this, because the bank made the decision to amend the complaint. When they moved for service by publication, they included the affidavit of due diligence that said the process server spoke with Ray Pacheco, and he said he was a son, Brian was a son, and they were living at the residence. So they knew. They decide, we're going to go ahead and file this amended complaint. And they make the allegation under 39-515 that they made diligent search, and I think their language is their identity cannot be known. They moved the court based on the statements and identity of Ray and Brian. They had actual knowledge. I'm not going to say they didn't. They decided to file the amended complaint. 39-515 then mandates service on the unknown errors. And the only way to do that is, because if they're unknown, truly unknown, is to serve them. So there's two flaws. One, they haven't joined what I think would be an indispensable party whose identity they know. Second, they've made let's just say incorrect allegation in their complaint. And then they try and serve one person, and the return says he is served as the unknown error, not on behalf of the unknown error. And the bank knew there was at least one other heir living at the property. If the bank has made that decision to affirmatively amend, the statute requires service, Rule 125 requires service. How do we get around there not being service on proper service on the unknown heirs?
Here's my thought on that. It's undeniable that the motion to substitute parties filed by the bank was late. I think everything after that is invalid because they had not complied with the statute by coming in within the 90 days. So it's as though nobody came in and substituted and moved to substitute parties. So you have a situation where you've got the defendant who allegedly owns the property. That's another issue. And she dies. And so the statute says that if you don't bring an action in 90 days, it's dismissed as to the deceased party. If it was the bank's obligation to substitute, I think that rule would have said, then the complaint is dismissed.
So you just said something that struck me. So if this happens, there's no proper substitution, the complaint is dismissed as to Lenore Pacheco, meaning there can be no personal judgment against her estate.
Correct.
But I'm not sure that still answers the question of how do we give the process that is due to potential claimants.
Because the notice and the joinder was perfected as against to the original party who signed the mortgage and mortgaged the property. And at that point, it's incumbent upon whoever the successors are to move forward with any claims she might have had following her death. And that would have included a timely application to substitute. So
I'll ask you this question and then I'll ask the same question in rebuttal. Do we need to bring the bank in to this matter to make a determination?
that was going to be one of my points. I mean, what's happened is that Mr. Ferentz's client deposited $150,000. We deposited $150,000. The bank came in and scooped up $150,000. And if the ruling of this court is that there was no jurisdiction to enter the default judgment, then everything gets unwound and you're back to square one with 10-year-old foreclosure action. And I think the bank might want to participate. Concerning the merits, Mr. Ferentz and I are in total disagreement. My position, basically, as I've laid out, is that the district court, in the battle of the redemption rights, awarded the redemption of the property to the housing trust because Mr. Kaushal did not perfect his redemption rights. And I interpret the court's ruling being based on there was never proof of ownership. The matter was then appealed to the district court, and in a published opinion, the Court of Appeals ruled that Mr. Kaushal had redemption rights from 2 of the 4 heirs. And so it redeemed 50%. And since the housing trust was the second mortgage holder, it redeemed 50%.
And your position is that your client redeemed all. Is that correct?
It was originally. My position is that where things went haywire is that the published opinion of the Court of Appeals what was a final judgment, was a final opinion. All the timelines had gone. So we're now in the process of doing a judgment on the mandate after the mandate issues. Mr. Kaushal takes that opportunity to try to re-argue the merits. Court of Appeals takes the bait, and it issues a memorandum of opinion which changes the structure of the redemption, which is now that the trust has no right of redemption, and Mr. Kaushal has a right of redemption, but he's got new partners, and that's all the heirs of Lenora Pacheco, and so they've got to figure out what to do with all of them. Nobody likes that. That's why we're before this court. But our position is that the Court of Appeals had no jurisdiction to write a memorandum of opinion which modifies a published precedential opinion after all of its jurisdiction had been transferred to the district court. And the only thing before is whether some language in a judgment on the mandate followed what was said in the opinion. And so our position is that the memorandum of opinion ought to be stricken, that the judgment on the mandate ought to be confirmed, and Mr. Kaushal and the Housing Trust are partners.
Mr. Van Amberg, you're a little over a minute over your time. You can use 9 minutes of your rebuttal time. Or sorry, rebuttal.
That's fine. I think I've said what I had to say.
Yes, thank you, sir. Mr. Ferentz. You have 7 minutes.
Thank you, Senior Justice. Briefly, in response to the cross appeal, the procedural posture of this case on the first appeal was that the trust appealed a grant of summary judgment. The Court of Appeals in Kaushal 1 reversed the summary judgment in favor of the trust. The effect of that was to send the case back to the district court with 2 petitions for the court to decide which petition should prevail. The Kaushal 1 didn't say what petition should prevail. It didn't say that the 2 petitioners should become co-tenants. It simply reset matters and said both of these parties have filed petitions that met with the prereqs of depositing funds and filing the petition during the redemption period. The summary judgment granting redemption solely to the trust was wrong. Now district court, you figure it out. In Kaushal 2, Judge Hennessy, who wrote both of those opinions, explained that the position the trust took on remand was a misunderstanding. He said it pervaded the proceedings on remand. Of course, those proceedings were just the motion hearing, and then we're back up on appeal. So I think that argument just fundamentally misunderstands the posture of the case and what is meant by further proceedings in accordance with this opinion.
So is it your understanding of the first opinion? You just said it was remand to the district court to then wrestle with the very issue of with competing petitions for redemption, who prevails.
That's correct.
There's not really been an answer to that question at this point.
I think the court answered in Kaushal 2 what the statute says, which is that the 2007 amendments created a priority scheme whereby if a former defendant owner redeems, then the junior lien holder doesn't have a right to redeem.
But it has, okay, I follow that, but it hasn't wrestled with the fact that your client has 2 of the 4 heirs.
I think that's correct, Your Honor. I think that's fair to
I'm
say.
just trying to think, what is if we were to remand this, ultimately, go all the way back down, setting aside the personal jurisdiction issue, but if we were just to take this straight on, we would simply be plucking out of Shaw 2 a piece of the opinion that's small but mighty, saying affirm on that, reverse on the rest, and sending it back for whatever is going to happen next.
Certainly what Mr. Kaushal would like you to do, the court to do, is to affirm on the part of opinion that said that the trust lost its right to redeem because a former defendant owner, in this case, the assignee of the heirs, who by definition are former defendant owners under the statute, redeemed, and to reverse the part that said, but that created a tenancy in common with non-redeeming heirs, and send it back to
the commentary on contribution.
I honestly don't think, I think Judge Hennessy was correct that that part was premature, and I'll take responsibility for having raised that in the briefing and maybe invited him to go there or made him think along those lines. But I do think it's premature. I don't think that this court needs to go there. I do think 2 things that were said there were wrong. The idea that only one side of a co-tenancy can demand contribution is probably false. And that's in the briefing. And also I think that the Tell Realty opinion that also was written by Judge Hennessy prior to these 2 cases, where he said that a non-redeeming heir had no rights after the redemption period, no right to redeem and no right to contribute. I think that was correct. We actually asked, Mr. Kaushal asked for that to be made formal because we thought it was new law at the time, and didn't go that way. But if the court wants to go there, that's what I think Mr. Kaushal would ask. In response to your question to the 2 of us today about whether the bank needs to be brought back in, I think the remedy there would be the same as if the heirs had made a 160 before motion to set aside the judgment. If the judgment is set aside, then we're kind of back to the bank being in anyway. So I think that happens automatically if that's what the court does. My concern, and I don't know.
Should the bank have an opportunity to respond to all of these issues regarding service of process at this point? If we're going to decide the case on that issue, should they have an opportunity to be heard? And are they an indispensable party at this point, if that's ultimately the way this court goes?
As I understand the cases in New Mexico, this court, and there's no one to stop you anyway, and sua sponte, look into the personal jurisdiction issue. What I think would be the appropriate thing to do if the court decides that's a problem is to send it back for the district court to look at personal jurisdiction in the first.
To wrestle with it in the first instance.
There are some factual questions. I didn't, in my first time up here, did not understand. I think it was Judge Gurley's comment about there being a false allegation, but there I see that the amended complaint just say that they did a diligent search, and I think that's probably what he's talking about. Whether it's false or
I should have said to the record. That's right.
Yeah. So whether there's a false statement, that does sound to me like a fact question for a district court to look at. You know, unfortunately, we're going to potentially end up rewarding the bank for its mistakes here, but I'm not sure if you want to seriously deal with the jurisdictional problem, which you have to do, that there's much of a way around that. I do want to correct something that Mr. Van Amberg said. He seemed to imply that the 90 days after the trust had filed that had run. But if you go back and look at Jones v. Montgomery Ward, 1985 NMCA 094, 90 days does not begin to run until service has been made by Rule 5 under the parties that have already been joined, and by Rule 4 under those that haven't, including the personal representative. The very end of that opinion talks about the case.
Oh, it was me. I was wondering if we decide this issue on the service of process issue, what would you ask the court to do with the Court of Appeals opinion?
Kaushal 1 or Kaushal 2?
Well, since I asked both, but I was thinking more Kaushal too.
My gut reaction, not being informed by really thinking about this very much, is that if the court didn't have, well, personal jurisdiction is jurisdiction over the parties. So lack of personal jurisdiction only means that you can't bind the parties to a judgment. So I suppose it doesn't mean that the court didn't have the power to pronounce what was the law on that topic.
But it did have authority to pronounce its judgments, Shaw 1 and 2, as between both of you that are here before the court, Shaw and the trust.
In every case, the trust has been properly served. It has been properly foreclosed upon. Its rights are decided. I don't really think those get revisited, even if you remand it. You know, it becomes a defective foreclosure case where the unnamed party was the heirs, I think it would be. And so we go back and probably have to do service on the unknown heirs. One of the heirs, and this complicated my thoughts on this over the weekend. One of the heirs was served. I think it was Raymond. The court seems to be well aware of it. It sounds like there's a question of whether the language in the service was proper, but the heirs have at least one of them has been served and known of this. And I think it's fair to say that the two living ones have known at least since they assigned their rights. So.
Is your question answered? Okay, your time has expired.
Thank you, sir.
Thank you. Mr. Van Amberg, you have 9 minutes.
The only real comment I have is I'm trying to the jurisdictional issue aside, and it's probably front and center, not side. The position of Mr. Kaushal is apparently that in Kaushal 1, despite the language in that particular opinion relating to the trust satisfying its redemption obligations and redeeming 50%, and Kaushal having 2 out of 4 assignments from heirs, 50%, that was not a holding of the Court of Appeals. Instead, Kaushal 1, as I understand the interpretation here, essentially resolved nothing and just threw it back to the district court, which I think is not a reasonable interpretation, because when it went back to the district court, it went back to the district court on a mandate. And the only thing the district court did was to enter a simple form of judgment on the mandate. It didn't have any evidentiary proceedings. Then out of left field comes the Court of Appeals in a memorandum trying to modify another opinion, which was a published opinion. And if it was requiring further proceedings in the district court, how did it suddenly get an epiphany and write the memorandum of opinion in Kaushal 2? And again, I think it's the position and the request of the Housing Trust is simple, and that is the memorandum of opinion needs to be stricken. I mean, what does a practitioner do if it has an issue such as that between Mr. Ferentz and myself, does it rely on a published presidential opinion? Or does it rely on a subsequent memorandum that has no presidential quality? I mean, I don't know what anybody does with that. I think it's an aberration, but I think it ought to be removed from the record. Thank you.
Thank you, Council. Look, the court will first thank both parties for short notice, educating us on the service of process question. Very much appreciated. And we will take the case under advisement, and as soon as we're able, we'll issue an opinion. So with that, we'll be in recess.